Hello, everyone, and welcome to our webinar. We appreciate the fact that you've taken some time out of your day to join us, and hopefully you'll find the content to be both interesting and useful. I am Paul Wilson, and as you can probably tell by the opening picture, and also one of the principals in AEL Environment. We're an environmental consulting firm. And it's been our privilege to partner with Pamela Green at Gowling's in this webinar this morning. It's our plan that this will start a series of webinars that you'll be able to join in on that will give you some different perspectives perhaps on environmental site assessment work and remediation work and property liability. So hopefully we'll see you not only for today, but also in some of the future presentations. We do have a fairly broad range of guests that are with us today. And because of that, you may find some things more interesting than others, but we do have some facility to take some questions and also to follow up on those questions at the end. With an open Q&A session. So please feel free to use the chat function. Unfortunately, because of the number of attendees, we aren't going to be able to do the chat function through a live video stream. So if you use the chat function on your Zoom link, then you can get that information to us, and we'll be able to respond to that either during the seminar or in the Q&A session at the end. If there's anything left unresolved at the end, we will, of course, respond to those through future communications. We'd also ask at the end of the seminar, there will be a chance to do a follow-up survey. We would appreciate it if you could do that for us as well. The webinar structure is basically broken into two parts where I'll share some of our perspective at AEL Environment, and then Pam will share some of her perspective, and then we'll have the Q&A section at the end. So we hope to plan to get you out on time at 1 o'clock as promised. There will also be a future on-demand recording of the webinar that you'll be able to download a copy of if you want to share that or use that in future to get more information at a later date. I'd also like to start the webinar off just by acknowledging the fact that we're dealing with a topic that deals with land. Land has a very long life, of course, and part of that life has to do with some of the First Nations. So I'd like to just acknowledge that at least where I live and where our office lives was traditionally the land of the Mississaugas of the First Credit Nation, and that in the places where we live, we still have a home for many Indigenous peoples, First Nations and Métis, and we're glad to have the opportunity to work on this land and to help to restore some of the function of that land in terms of the work that we do, and also to join with them in creating a better future, as we have on a number of our projects, and I've always appreciated the input that they bring. So with that, I'd like to start on the technical part of the presentation. In terms of the agenda, we are going to give you, we've just given you some introduction remarks, but our focus at AEL is to always provide an idea of what our client's risk profile is in terms of our work. Different clients have different needs, and so we'll try and run through what those risk profiles might look like, and then also how we approach resolving those risks, and also be able to answer any questions that you have. If we can move to the next slide. With AEL, we're a very practical-oriented company. We deal specifically in the area of contaminated sites investment and management. So this kind of work is what we do all day long. and enjoy doing it. And as part of that, we've developed a number of innovative land restoration solutions by using the tools that were provided in site assessment and also remediation. And we hope to develop some of those topics in the future with some of our other webinars as well. We can go to the next slide. This is there are different kinds of risks, and we always like to start the conversation about risk off with an understanding about what absolute risk liability is. In terms of absolute risk, what that really means is that the MOE can come in very rare but real situations. They can come, and if there's pollution on your property, they can charge you. There are criminal charges that are available under the Environmental Protection Act. And those, in our case, on the kind of work that we do, they usually fall into the categories of if there's contamination beyond your property boundary in either the groundwater or soil, and or if there's presence of free product like gasoline or diesel fuel or chlorinated solvents in the subsurface, then the presence of that free product is going to be a trigger for the regulator. Generally, that can be, I've just been told my video is off. Is it, has it come back on yet?
Yes.
Okay, great. Sorry about that. In terms of the kinds of risk that we deal with respect to absolute liability, those can generally be handled if you follow due process and you're aware of what the issues are, and we hope to provide you with some of those due process things that you can work your way through. Other than that absolute risk, there's also, we were talking before about some changes that came through with what actually was the COVID legislation in September, that came into effect in September, that had some impact on the Environmental Protection Act, the federal regulation. Pam, do you want to jump in and say anything about that?
Yes, and I'm just going to say that it affects the Environmental Assessment Act and the way assessments are conducted. The purpose of the legislation was really to try to streamline the process, avoid some of the duplication. Our initial analysis of it is that we're not sure it has done a great deal on either front. It was supposed to modernize the process, and again, not necessarily at the current stage until regulations come into effect. So we'll wait and see, and we'll be able to report further on how that plays out in the future.
Great, thanks. So in terms of understanding and mitigating risk, we're dealing now, our topic is about if we can go to the next slide, the understanding and mitigating risks come through, there's a sorry, there's a typo on this slide. It should be a phase 1 environmental site assessment, should be the first heading. At least that's what I have on my screen. But if you can, if you're contemplating the purchase or the sale of any real property, particularly industrial commercial property, then you're probably aware of the stages of understanding what the risk might be associated with that. And that, of course, comes through phase 1 environmental site assessment, which looks at the historic use of that property and the potential for contaminating activities to occur there. So the Reg 15304 has a list of, I don't know, 150 or some odd potentially contaminating activities. So it's fairly comprehensive. And in a phase 1, we would go through that kind of a list and come up with potentially contaminating activities on a property. The phase 2 is simply the step that you take to get soil and groundwater samples to determine if those potentially contaminating activities are real and actual resulting in the actual contamination of the property. Once
Paul.
you've determined, yep.
So if we're going to interject on a couple of fronts, the one thing I always like to note here is that the list you just referred to, it's a mandatory list where you as the consultant have to say to the client, a phase 2 is recommended, correct?
Correct.
It's a question that comes to me very often from clients thinking that it's an unnecessary step to proceed to a phase 2, but in fact, it is regulated.
Well, if you want to follow the process, it's not like we can take a phase 1 and say any risk that you have here is not applicable. So if in terms of managing that risk, if you want a determination from your consultant that that risk is real or not, then yes, a phase 2 is required. In terms of the mandating, in certain circumstances, it is mandated, like if you want to do a change in use on the property and you have to get a record of site condition, which we'll talk about later, then you are mandated to do a phase 2. But in terms of the mandate of actually doing a phase 2 environmental site assessment, sometimes clients feel comfortable not doing that. We, of course, don't recommend that, and I'll give you a bit of a case study about why that might be a good idea to do that a little bit later on in the presentation as well. But the main thing is that our position is that in terms of risks, there is no risk on a property that can't be managed and can't be managed appropriately. Irregardless of your appetite for risk, it can be managed, and we can help you work through that process. There are different tools that are available, and we'll talk about those a bit now. If we can go to the next slide. The first one of the tools is really what is the standard of care, right? So in environmental site assessments, as in most other things, you have a standard of care that basically outlines the level whereby you need to provide due diligence in the work that you do. So no matter what it is, you'll have a standard of care. Our opinion is that the standard of care in Ontario is governed by an Ontario regulation called 15304 and its subsequent revisions. There was a major one in 2011, and I think 2014 had another one, and perhaps there's been another minor one since. But there has been some changes in Reg 15304, but that defines the regulatory standard of care for environmental site assessments in Ontario. It's a prescribed process, and it can offer some liability protection on the part of the owner if you obtain a record of site condition, which is part of that regulation. If we can move to the next slide. Under Reg 15304, there are some things that take time to complete if you wanted to follow their process exactly. For instance, freedom of information requests take time to receive the responses from, and sometimes in a property transaction you don't have those that luxury of getting the FOI requests. There are some other things as well, but in terms of modification to Reg 15304, we generally call those a Canadian Standards Association report or a CSA report, which is also governed by a standard that was developed by the Canadian Standards Association. We do suggest that you follow the Reg 153 process and then note the modifications in the CSA report so that it's clear where you don't meet the more stringent standard. The nice thing about the CSA report is, as I mentioned, it's faster. It's generally more cost effective, probably half the cost perhaps, or maybe not quite. And in terms of following the direction of Reg 153, it provides the ability to note the deviations from that reg. It's also more common because of the timing in terms of real estate transactions. And then you can see when it comes to Reg 15304, where the difficulties might lie in terms of following that process. In some cases, it is mandated, particularly when you're moving to a more sensitive land use. So if you have a tenancy that, for instance, in an industrial building that's going to daycare, they'll probably ask for an RSC. If you're changing your use from industrial to residential, you will certainly need an RSC, and there are some other occasions where that's required as well. Those are usually triggered by your planning applications or your building permit applications. They'll flag it at that time, and we're certainly able to help you out with those. If we can move to the next slide. I'll touch on this a little bit. The Reg 15304, the purpose of that was to provide really a process where we could redevelop brownfield sites into residential or more sensitive land uses in the province of Ontario. So it's required under those circumstances, as I mentioned before. What is nice about it is that if you get an RSC, then in the process of doing that, then your ability to get some environmental property liability from the Ministry of the Environment or the Government of Ontario is embedded in the regulations. So that is extended. It generally means that if you have an RSC on the property and the standards change with respect to that property, that they won't retroactively go back and ask you to update to the new standard with respect to the remedial work that you've done or the risk management processes that you put in place there.
So Paul,
yep.
I'm going to talk a little bit about the difference between civil liability and statutory liability. And this is one place where it makes a difference. When Paul is talking about reducing environmental property liability, here it's with respect to really orders to clean up from the ministry. It could be used as a baseline study to form a defense for civil liability, but I just wanted to know the difference between the two, and then I might elaborate a little bit more when I do speak.
Right, and that's why we focus on the idea of having an appropriate standard of care for the work that you do, because of course that is going to form the basis of your defense in civil liability, as Pam mentioned there. The nice thing about having an RSC is it gives you a third party, that being the Minister of the Environment, gives you a third party verification of the work that you've done as to meeting the standard of care or the regulation under Reg 153. So sometimes clients like that because it gives them that third party verification from an entity that has control over that kind of work. So it's valuable in that sense. Let's go to the next slide. We'll talk a bit now about phase ones and defining are there any risks. Phase ones, I apologize if this is a review for some of you, but basically phase ones look at potential liabilities through a site inspection and historic review. It gives you an idea of what the potential environmental liabilities may be on the site. We call those areas of potential environmental concern, or APEX. And it looks both on site and for neighboring properties, generally within a 250-meter buffer zone around the site. And it really gives you your first layer of liability protection by following that standard of care in a phase one. We can go to the next slide. The next slide takes the phase one and shows you that that you may have areas of potential risk. So this particular property is a former Canadian Tire site. We like to use it because everybody knows what Canadian Tire looks like. So they used to have a gas bar, a garage, of course, a garden center. And so all of those areas, if you look at the list under Reg 153, would appear as areas of potential environmental concern, and so therefore need to be investigated. If we can move to the next slide. So the phase two, what it really does is determine how big the risks are, and it confirms and quantifies if they are present the areas of those impact as indicated by the Phase 1 ESA. And it's required, of course, where an RSC is the goal or where an APEC has been identified in the Phase 1. You can't, well, your consultant, if he's following the standard of care, won't be editing Phase 1 report to remove APECs unless there is a clear line of evidence that that goes along with that. So it's important to get a Phase 2 to get that APEC off the list, especially if it's fairly minor in nature. And then the Phase 2 is often updated during subsequent phases of the work. For instance, if remedial work is done or something like that, then the Phase 2 would get updated to reflect the elimination or the reduction in the risk associated with that that work. If we can go to the next slide. So that's the process in terms of standard of care, and this is really when it comes to managing the risk. You have a couple of choices for risk management under Reg 153. One of them is remedial options. Of course, there's always the traditional excavate and disposal. We tend not to use that, not just because it's just moves the liability to another location, but also it's not as cost effective as it used to be. We do have approaches that that make that managing that risk better through on-site testing, so that you're not removing anything that's not impacted, but you're not slowing down the project. We also use extensively in situ remedial techniques and bioremediation associated with that as well. But one of the main tools that's in the toolbox for managing risk is through risk assessment. Falls into a number of categories like segmented record of site conditions or risk management measures, and also the movement of impacted soil around the site under a risk management plan, so that you can manage your risk that way. I often like to use the example, if you're familiar with Toronto, that there's a park that's right down by Skydome, has a canoe on it. Lots of people pass the big red canoe on a daily basis on the Gardiner Expressway. That is actually contains all of the contaminated soil from the former railway lands at Skydome when it used to be a rail yard. So the ability to relocate soil and have a risk management strategy about that is a strong one. Let's go to the next slide. So under Reg 153, you have two things. You have generic criteria, and a lot of people are familiar with table 1, 2, or 3 in terms of that generic criteria. And it also has the ability to generate site-specific based on risk assessment when meeting those generic criteria is either not possible or feasible to remediate. What's important to realize is that when you follow the risk assessment process, you're actually, for a site-specific basis, you're actually following exactly the same process that the MOE prescribed in developing the generic criteria, except that you're doing that on a site-specific basis. What that means is that you end up with more projects that are able to proceed to redevelopment, and you can manage those in terms of the environmental protection that's required for that land use. We can move to the next slide. Site use determines your site criteria. If you happen to live in Guelph, where they use the water for potable purposes or for drinking water, then you'll have to meet one table that has lower numbers for potable groundwater. But if you live in Toronto, where they don't use the drinking water from groundwater, then you can go to table 3. So that's just a really straightforward means of illustrating risk assessment types of approaches that are available under the regulation. With respect to that criteria, though, risk assessment, of course, allows you more flexibility. If we can move to the next slide. This gives you an idea of what risk you have and the flexibility that can come out of that. If we can move to the next slide. And we'll talk about how risk assessment works. People know this intrinsically, but risk assessment happens through three things. How toxic is the chemical that you're dealing with? How much of that chemical are you going to come in contact with or be exposed to? And then how are you going to be exposed to that? So generally in our kind of work, we can't change the chemical. It's already in the ground. It may be a chlorinated solvent. It may be a petroleum hydrocarbon. It may be a metal. But in the context of the chemical, we can't really change the chemical because it's already there. In terms of the dose, we generally can't change the dose unless you're going to remediate that and bring the level of the contamination down. But what we can do is we can change the exposure pathway, and that's really the element of risk assessment that is important, is because we can block those pathways. So for instance, everybody knows you can take a bottle of Tylenol and hold it in your hand, and there's really no risk associated with that. But if you take that bottle of Tylenol and you swallow it all, then you're probably going to have to get your stomach pumped out. So that's an example of exposure pathway. The dose is the same, the chemical is the same, but the exposure pathway is different. So that's essentially what we do under a risk assessment, is we change that exposure pathway. And in certain instances, change the dose through remediation. If we can go to the next slide. These give you some illustrations of what that is. So the chemical is determined from either generic or site-specific criteria. You reduce your dose through remediation, and the exposure pathway allows you to block it with like an asphalt cap or perhaps a parking garage, or intercept that with some venting plan. If we can go to the next slide. Another area of risk is data quality. I'm not going to spend much time on that, but it's something that we tend to look at a lot in terms of making sure that your data is correct and managed appropriately on a site. If we can go to the next slide. And these are the elements of things that if you're looking at a phase 2, these come out of the Ministry of the Environment's for the top 10 list, I guess, of things to look for in a phase 2 when they come in terms of non-compliance. So they fall into the categories of things like lateral and vertical delineation, not enough groundwater sampling, not enough wells, an ESA that's out of date. They use the criteria of 18 months. So we generally tell our clients that if the MOE doesn't like it after 18 months, maybe you need to consider whether you want to rely on it as well, or have an update done. Sometimes the wrong table is used. We often see that where either a more sensitive or less sensitive table is used. Or the phase 2, this is less common now because a fair bit of time has passed, but we have seen reports where the phase 2 doesn't reference the right standard. Sometimes we see not all of the contaminants concerned are considered, and not all the potentially contaminating factors are concerned. So in terms of managing your legal liability, it's our focus is always on what's the appropriate standard of care. And how can you manage both your regulatory liability and also your civil liability, as Pam talked about. If we can go to the next slide, I'll pass it over to Pam, and she can talk about her perspective on this.
Great, thank you, Paul. So my name is Pamela Green, and I am a partner with the law firm of Gowling WLG. I work primarily out of the Hamilton office, And I used to be able to say that that commute was so much better than going into Toronto, but now that has become utterly irrelevant. My practice is commercial real estate. A majority of that practice is development work. And I deal with a lot of contaminated lands. And I'm going to say that I will deal even more so with contaminated lands, as legislation over the course of the last decade has led to much more intensification and therefore a lot more brownfield redevelopment. So next slide, please. I am a transactional lawyer, so I deal with developing land, buying and selling it. But the firm does have an entire environmental practice group, and we are actually nationally and internationally known as one of the best practices in the country. And then I have to tout that we've actually won an award at the Environmental Law Firm of the Year for 2020. Next slide, please. So I had mentioned this before. Liability can be one of two, either civil liability or statutory liability. Civil liability is based upon your traditional cause of action and your litigation, whereas statutory is about what is in legislation, what the regulations are. It's mainly under the Environmental Protection Act, but secondarily, it could be under the Ontario Water Resources Act. Next slide. So the EPA, it has a statement in it that is of utmost importance. It states a person who owns or owned or who has or had management or control of an undertaking or property can be subject to broad administrative orders in relation to contaminated sites. And this is really important because what it means is that the owner, the past owner that caused the contamination could be held liable for an order. The interim owner that ignored the contamination and allowed it to migrate off-site could be held liable. The current owner who has no idea about the contamination because they didn't do proper ESAs, they didn't hire Paul, any one of those parties could be held liable. The next point there is that the liability doesn't have to be apportioned between potentially responsible parties. In fact, it doesn't even have to be responsible parties. It could be completely innocent parties. Next slide. Breaching the EPA has certain penalties, 6 million for individuals, 10 million for corporations, plus possibly going to jail. That is in addition to the cost to clean up. Next slide. So comparing the two contexts of liability, on the civil side, who is responsible or who is subject to liability? That's the person who actually caused the contamination. Whereas on the regulatory front, that's not really relevant. It really is the status. And that's back to the definition I just read about, the ownership, management, or control. What are you liable for? In the civil context, it's to remedy the damages incurred by somebody. Whereas in the regulatory context, it can go beyond just the cleanup of damages. I will talk about a couple of cases, but you may be required to clean up historic contamination, and you may also be required to do work and possibly remediation on other lands. The last part, where does the liability arise? Well, in the civil context, it's wherever you caused it. Whereas again, in the regulatory context, it is anywhere where that contamination can be found on your lands or off your lands. Next slide. So we like to name the two areas: civil, buyer beware; regulatory, buyer be scared. Under the civil context, this is a great quote. Absent fraud, mistake, or misrepresentation, a purchaser takes existing property as he finds it, whether it be dilapidated, bug infested, or otherwise uninhabitable or deficient in expected amenities, unless he protects himself by contract terms. This is and will be the center of a whole other presentation, contractual terms and how to try to protect yourself. But basically what it means is that you are responsible for the contamination on your property. Paul had mentioned that the ministry could come in to your property and say you need to clean up. Just giving some examples of that. If you have a piece of contaminated land and it is not causing a health issue, i.e. there are no fumes that are coming up through the floor slabs, making the employees or the tenants sick, or the contamination is not migrating off site, you could technically leave the contamination there. So regulatory. In this instance, there is case law, and I will talk about it, that means that the liabilities of past owners could actually run with the land in the same way that a restrictive covenant might run with the land. So you can be held liable for contamination that may have migrated off your property prior to you ever even owning the property. Next slide. So I'm trying to look at a chat here. Yes, we'll get to some of that. Section 18, no fault orders. And I bring this up because this is the crux of the issue where liability is concerned. Section 17 deals with polluter pays. Section 18 deals with where you are not at fault and yet you will still be subject to a cleanup order. I've highlighted, this is from the actual act. I've highlighted a couple of clauses in the same that I've mentioned. Anybody who owns or owned or had management or control. We will talk about some cases that define what that means. And then of course, the idea behind this is to prevent, decrease, or eliminate an adverse effect. The entire nexus in the Environmental Protection Act is to protect the environment. And that is an overriding protection so that the individuals that are subject to any particular orders may have to bear the cost of protecting the environment for everyone in general. Next. Fairness is irrelevant. The act is so broadly worded that it doesn't necessarily matter whether you caused the contamination or could have done something about it. There's a follow-up question. This is a case where we had an owner on one side who caused the contamination. That contamination migrated through property owned by the city of Kawartha Lakes, and then it went off and into a lake and contaminated it. Of course, the owner that caused the contamination went belly up, so had no money. And that meant what the ministry did was they stepped in, they issued an order against the city. And you can see the quote here, where environmental work is necessary, the environmental protection objective of the EPA takes precedence over the polluter pays. This was actually upheld. Next slide. Who else could be the subject of no fault orders? I will talk about a couple of these cases, but if you look down the list, it is pretty extensive. Tenants, accountants, real estate agents. I will mention a case about that. Estate trustees, investors, lenders. I know there are a few lenders in the audience today. And on that list, you could also add lawyers potentially, depending upon the fact situation. So again, what is irrelevant here? It is irrelevant how long a party may have owned or managed or controlled a property. It doesn't matter how long ago the contamination occurred. And the worst part is fault or fairness, completely irrelevant. Next slide. So this is from some case law that looks at who is in management or control, and it's really about who can dictate what happens on that property. So you don't have to be an owner. You can be somebody like a lender that is taking a very active role in dictating what an owner does or doesn't do on its lands with respect to environmental cleanup. So it's important to look at those factors. Doesn't mean you are necessarily involved in the business. It does mean you have some control over it. Next slide. In this case of Baker, the one point that I would like to make is that unlike a corporation where officers and directors may be protected by the corporate veil, there is no such thing under the EPA. It pierces the veil right through to officers, directors. shareholders, employees, again, looking at the overall definition of management or control. In this case, what happened was the company did decide to do the right thing. It's just they didn't set aside enough money to do the right thing before they went belly up. Ministry came in and ordered against the directors and officers to clean up. McQuiston is a case that I like to bring up because it's a lesson to be learned by everyone. In this case, there was a real estate brokerage and an accountant who were trying to help out an owner who was out of the country and who did not speak a lot of English. So unfortunately, what they did was the brokerage, they held the keys. That's kind of self-evident. They were the main contact, maybe also self-evident in doing your job as a broker. But they were also named in the waste manifests, and they did actually show the ministry the property when they came in for an inspection. That was seen to be an active role. The accountant also held a power of attorney and signed some contracts. So the lesson to be learned here is that you should never sign anything on behalf of someone else. In this day and age of electronic communication, emails, etc., there's really nowhere in the world, almost nowhere, that a client owner shouldn't be able to sign their own documentation. Next slide. So Hamilton Beach is about where you can be required to clean up or conduct work. In this case, there was a property that was contaminated by a former tenant. Tenant's long gone. Ministry comes in and they issue an order against the past owner, the current owner, and the current tenant, Hamilton Beach. Hamilton Beach was in fact our client. None of those parties caused the contamination. Next slide. The issue in this case was that the ministry came in and said that these parties had to conduct investigation on the adjoining lands to find out how far and to what extent the contamination had in fact migrated. And so what we attempted to argue was that the ministry could only really come in and tell you what to do on or with your property. But they came back and said, no, there's really no geographic limit to our ability. And in the divisional court, the statement in the last part of the slide is very indicative, giving the director latitude and flexibility to issue an order to any person with a nexus to the contaminated property, because that furthers the purpose of the EPA. So again, back to the environmental protection being paramount. And that's where we are at today. This case did not go as far as to say, and any of those orderees must clean up the neighbor's property, but it left that question open. Next slide. Back to nexus. Who? What is the limit of the ministry's environmental powers? It seems to be growing with yes, this is the fear, and this is why actually we are out here doing some of these seminars in order to educate. It is an, what's the word? It's a broad power that has been interpreted more and more in favor of the general protection as opposed to the individual. So who can be responsible? An owner that owned for even one day, an owner of clean property. In fact, Hamilton Beach's property was not contaminated and didn't require cleanup. It was a contamination that had previously migrated over to the adjoining site. Next slide. So what does this mean? How do you protect yourself? Due diligence, absolutely key. And Paul has spoken a little bit about that, but you need to understand what is on your site itself and what is on the adjoining sites. So part of an ESA is looking at the uses of adjoining sites. You need to know what happened in the past. You need to know what's happening in the future, and you need to know what you will be doing, or sorry, what is happening now and what you will be doing in the future. It's important that this is an ongoing thing. Anything can change from day to day, either on the adjoining lands or on your lands. So if you are in an area where there are particular uses that could cause contamination, you should make sure that you have an ongoing monitoring process in place. So that means the importance of due diligence is really, it can't be understated. Next slide. I put this in again because I saw a couple of lenders, but for lenders, there are some protections under the EPA, and that's basically because there is a recognition that it is better that lenders, secured creditors, can actually go into a property and do certain things without being deemed to be a mortgagee in possession. So permitted actions, they can investigate the property, they can preserve it or protect it, so they can change locks, they can actually do a little bit of cleanup work if that is responding to an environmental hazard, to prevent from going off site, for example, or the one I talked about with maybe fumes coming up through the floor slabs. Next. I'm going to skip that one. Next. Skip that one as well. I'm just cognizant of time here. The lender protection does have some limitations. So you can see it's a 5 years. A lender can't go in there and act willy-nilly. They do in fact have to abide by a certain standard. And of course, if there is a hazard or a danger or a serious risk, they do have to deal with that, and they will not be protected from orders. Let's go to the next slide. The same thing goes for receivers and trustees in bankruptcy. They have certain protections under the Act. There is one further thing. The secured creditor provisions basically prevent a secured creditor from being deemed to be in possession, but a receiver or a trustee in bankruptcy, they are actually in possession. And so what happens is if they find out about something really nasty about the site, they can actually back out. It's called a bailout clause. And in that instance, they can relieve themselves of what might otherwise be exposure to liability. Next slide. Lenders in possession, and this is why the provisions in the EPA are so important for lenders, because if you do become a mortgagee in possession, you are the same as anyone else, subject to all of the same exposure to liability. And so what should you do? You should appoint a receiver or a trustee. Next slide. Some of the ways that you might be able to protect yourself. Pollution liability. This will cover only where there is unknown pre-existing pollution. So if you have a property that you are coming into and you do environmental assessments and they do not disclose anything, it does end up being contaminated, you will have coverage there. It may be that your particular property that you're buying didn't have a use that would be indicative, but somebody on the neighbor's property has one of those uses, dry cleaning, gas station, that sort of thing. That would provide you some protection as an owner. Where you do have a remediation or a risk assessment plan, there is a product out there. We haven't seen a lot of it in Canada. I don't know, Paul, whether you're seeing any more these days, but if there is a remedial plan and an insurer can take a look at what that risk is, they will charge you a premium, a fairly large premium, but it does then de-risk the problem. Paul?
Yeah, our experience with those kinds of either cleanup or cost cap or those kinds of insurance plans is that they're really tied to the cost of the remediation, and so you're generally better off just doing the remedial work than trying to find an insurance policy that's going to cover it all for you.
The last part that I want to mention is the errors and omissions liability insurance. So people like Paul have that in their pocket, but directors and officers, I have mentioned they can be personally liable. There's a lot of D&O insurance out there. That coverage most often excludes environmental issues. So please review your policies or have them reviewed and make sure that there is an actual endorsement added where you are dealing with land. Next. So what I have done now is maybe told you about all of the bad news and maybe scared you a little bit about all of this exposure to liability. And what I'm going to reiterate here is that um, contamination could be good, bad, or ugly. Paul has said you can really deal with contamination, any contamination. It's really a matter of how you deal with it and the cost of it. So there is, generally speaking, a way to manage. So cost and the time to remediate or do a risk assessment are important, but it does mean that projects can move forward, notwithstanding that there is contamination.
And just to interject, just interject on that process as well. There's been a couple of questions about how the Ministry of the Environment interacts with property owners when you have to advise and things like that. If you're embedded in the process and you're following the process, then there are certain points in the process where it is appropriate and in some cases necessary to contact the Ministry of the Environment and to provide the information that you've got with respect to the property. If you engage with the Ministry of the Environment within the process where they're expecting it to, then generally that conversation goes well. If the Ministry of the Environment comes in and finds out that there's an issue on your property without you having engaged in that process, like a phase 1, phase 2 risk management plan, then the conversation may go a little bit differently. So it's important to recognize that the Ministry of the Environment has created ways to interact with them. Another thing is that there's been a couple of questions. There's been a question about reporting. Reporting within the process is appropriate. These are generally not, most of the work that we do is generally not coincident, although it may have occurred from a spill. It's generally not considered a spill under the Environmental Protection Act in terms of the historic contamination that's there. The event may have been, but or in other words, it should have been reported at some point in the past, perhaps. But at the time that we do our work, it generally doesn't have to go to the Spills Reporting Center. Maybe you've got a bit of perspective on that as well, Pam, about how you communicate and what the appropriate means of communicating with the Ministry of the Environment are?
So I would actually reiterate what you have been saying. There is an overriding obligation if in fact it will cause or it will be dangerous to either humans or animal life, animal and or plant life, I believe. So certain types of contamination, there are reporting requirements. But as I say, if in fact you are dealing with it on your own property and it doesn't present that risk and it's not migrating off, you don't have an obligation to report.
So hopefully that's addressed some of those questions that are out there for that.
There's another good question for you, Paul.
The response time act, is that the one you're,
Yes.
There's a question about the response time from the Minister of the Environment. It's a bit hit and miss. If you're engaged in the process, they have mandated response times. So for instance, within the submission of an RSC or of a risk assessment or things like that, then the Minister of the Environment has to respond it's monitored in terms of whether that's 45 days or 90 days or whatever the mandated time is, then the ministry does respond within those. We found them to be quite good in terms of responding. Unfortunately, sometimes the response is, we want you to give us more information. And they take 3 months to tell you that, and then take another 3 months to review the next submission. So unfortunately, even though the response may be within the appropriate time, it is sometimes not as optimal as you would like. We also find that the district office is very good at responding to questions and very very interactive. We've had great interactions with the district, and we were actually involved in a complicated not-for-profit housing development where we had some tight timelines that were affecting some of the funding. And the Ministry of the Environment, both at the district level and at the regional level, came to the table and participated with us to try and clear some of those roadblocks. So it's not always bad news in terms of dealing with the MOE, but it can take inordinately long to what we would expect it would take.
So
there's a question about, sorry, go ahead.
Yes, and another question about who owns the contamination passing through the property, the victim or the source of contamination. So I'm not quite sure about the context of the question, but I will say that where ministry orders are concerned, it belongs to whomever has the deepest pockets. So it's gone off site. Go ahead.
I was just going to say independently and severally, right?
Correct.
Like you can be responsible for all of the remediation, even though you didn't cause it, and even though you don't own it, you may be responsible for all of the cleanup.
Correct.
It's very draconian, I think, but that's the way it looks like. Mm-hmm. And I think that reinforces even more the appropriateness of making sure you do appropriate due diligence and know what's going on in your property, so you can take some mitigative actions and get ahead of that curve, because there are things that you can do to manage that risk as long as you are aware of it and work through the process.
Yeah. So there was a thank you. That's scary. One other scary thing, although we shouldn't maybe end on a scary note, but if you are the subject of an order and you weren't the cause of the contamination, the little bit of bright news is that there is some what I'll call obiter commentary within the tribunal cases, that the fairness or the fault is talked about and perhaps one day might actually be a defense. The problem is that you can appeal an order, but what that doesn't do is stay your obligation to do the cleanup. So you have to do the cleanup, you have to incur the cost. At the end of the day, you could be successful in the appeal, but you've already spent the money. Then you have to go backwards and chase parties that might have been responsible and at fault. But obviously, if the order was issued against you, it's probably because that party doesn't have any money. So that's also a little bit scary. We deal with those types of problems within our environmental group.
Great. I'm also cognizant of where we are on our timeline. There was an earlier question about mandatory phase twos. Phase twos aren't always mandatory. If you have a clean phase one, then you can submit a clean phase one for a record of site condition. But if there's apex identified in the phase one, then you have to proceed to a phase two within the context. Unfortunately, we don't deal with a lot of sites that have clean phase ones that need a record of site condition. So sometimes we miss that particular avenue. Well, we don't miss it when it's there. We just miss talking about it in the context of a presentation like this. But generally speaking, a phase one, phase two are all required for an RSC.
Right. Just so everybody is aware, APEC?
Area of potential environmental concern.
Okay.
Okay, well, thanks very much. We're at the end of our time.